After 5 centuries of dynamic development, the Islamic legal system reached a stage of maturity that culminated in the derivation of the objectives of the Sharia, also called the Maqasid al-Shariah. These objectives or purposes laid the foundation for the development of a system of discretionary justice that was intended to solve legal problems in an area where the texts were silent or did not provide express or implied solutions. The Maqasid are the 5 ultimate principles that the Sharia places before us as objectives or goals to be achieved. The word qasd is also translated literally as intention, and in this sense, these 5 principles reflect the intention of the lawgiver. The purposes of law are divided into 2 types: purposes of the hereafter and purposes pertaining to this world. The worldly purposes are further divided into 4 types: the preservation of life, the preservation of progeny, the preservation of intellect, and the preservation of wealth or property. Each worldly purpose is meant to serve the single purpose of the hereafter. When all types are taken together, we have 5 ultimate purposes or principles of the law. When stated as broad principles, we have the following statements. First, religion or the religious system must be preserved and protected. Second, life must be preserved and protected. Third, progeny or the family system must be preserved and protected. Fourth, intellect must be preserved and protected. And fifth, wealth or property must be preserved and protected. These 5 purposes are designated as necessities and are the primary purposes of the law. These are followed by second-level purposes called the hajiyyat or needs, which are additional purposes required by the primary purposes, even though the primary purposes would not be lost without them. The third level of purposes is those that seek to establish ease and facility in the law. These are called the complementary values. The purposes are classified in several ways in order to highlight the relationship of the purposes in or see. The classification of the purposes of Islamic law is an attempt to guide the judge, as well as the policymaker, as to which interest will be preferred in which situation. The importance of the individual purposes within the necessities is reflected in the order in which they are stated. Thus, protection of religion has precedence over life. Life has precedence over progeny. Progeny has precedence over intellect. And intellect has precedence over property. This is not all. Each of the primary purposes may be divided into public and private purposes. The public purposes seek to preserve the interests of the community a whole, while the private purposes protect the rights of individuals. Again, the purposes are divisible into those securing the rights of Allah and those preserving or protecting the rights of the individuals. There is a fine distinction between the 2 kinds of divisions, though many modern scholars tend to consider them identical. The distinction lies in the fact that there are 3 kinds of rights to be identified rather than 2. These are the rights of Allah, the rights of the community as a whole, and the rights of the individual. It is to be noted that in general, public purposes will be preferred over private or communal over individual. But this does not give rise to a system like that of Jeremy Bentham, which crushes human rights in the face of the public interest or the greatest good or the greatest number. The relationship that exists between the primary purposes may be highlighted by visualizing outer shell serving or protecting the inner shell or shells. Thus, the innermost shell is represented by the preservation and protection of religion. This represents the foremost purpose of the Sharia. The shell surrounding it is that of life, which is itself surrounded by progeny and so on. The outermost shell is that of the preservation of wealth that serves all the inner shells and is subservient to them. Each primary purpose considered to be a necessity has its own supporting needs and complementary norms. These are also to be viewed as shells, one inside the other. This relationship is explained by jurists through examples. Considering the example of prayer, we may say that the essential parts of the prayer are its elements and obligations. Whatever is besides these is meant to complete and complement them. The parts of prayer are distributed among the purposes in such a way that each outer shell forms a protective boundary for the inner shell. One who crosses the outer shell or boundary will soon demolish the inner shell. Thus, the person who gives up the nafl prayers will soon give up the sunnah prayers and will finally demolish the faraz. There are many instances in the law that correspond with the analogy of nafl and faraz. For example, even a drop of wine or a small quantity of it is prohibited because it leads to the consumption of larger quantities, though it does not intoxicate or damage the intellect. A severe penalty is provided for stealing a thing of small value, as it leads to the stealing of larger amounts and to robbery. In the same way, the ethical and moral norms hover around and protect the main and essential legal norms. The needs and complementary values are, therefore, to be considered the servants of the necessities. The relationships described above indicate that some purposes have a higher priority than others. That is, they would be preferred in case of a clash between two interests. This fact also highlights an important point that while deciding a legal case, or while attempting to understand the position of Islamic law on an issue, one cannot look at one purpose or interest alone. There is always a clash of two or more interests. This is achieved through the machinery of organized political society that seeks to strike a compromise between the conflicting wants, desires, and claims of individuals and between the competing interests. Looking at the purposes of law alone and identifying the priorities that exist between them would present a simplistic view of things. The purposes are always used as a reference point for the general principles of the law, and this makes the situation highly complex. Nevertheless, the purposes, when considered alone, present a fair picture of the entire system, even for the layman, who is not trained in the law. If he observes a few rules, he can easily determine the answer to a question that he may have about the law. The description provided does not exhaust all the relationships that exist between the purposes, but what has been said will suffice as an initial explanation.